Congratulations on your upcoming marriage. What an exciting time. I'm Rosanna Berardi, the Managing Partner at Berardi Immigration Law. Getting married is one of the most important steps in your life. And getting married to a non-U.S. citizen can be one of the most stressful times in your life. But don't worry. Today we'll go over all of the options to make this process as easy and stress-free as possible. So if you're a U.S. citizen or a lawful permanent resident, also known as a green card holder, you can apply for your foreign national spouse to obtain a U.S. green card. But recently, the U.S. Department of State issued a new policy memo regarding the entry of foreign nationals who enter the U.S. as visitors and then partake in actions within 90 days of entry that are inconsistent with what was represented at the time of admission. So what does this mean? U.S. citizen or lawful permanent resident to take up residence in the U.S. And basically, the Department of State is saying if you enter as a visitor for some reason and you marry, you must wait 90 days before filing your green card petition. If you enter as a visitor, marry the next day, and file your green card petition the following day, there's a presumption of fraud and misrepresentation, which may lead to the denial of your case. So you've got to be careful. So let's talk about how this all can come together. Let's discuss the first step and probably the most exciting one, your marriage. The U.S. government requires couples to be legally married in order to obtain a U.S. green card. The marriage can be religious, civil, big, small, in a church, or on a beach, wherever you choose. But please make sure that it's a lawful marriage that results in a marriage certificate. So you're married. Now what? Well, congratulations. So what happens next? Well, it depends. Typically, the U.S. government would like to see marriages occur and then have the foreign national spouse wait outside of the U.S. until the green card process is concluded. Upon the marriage, the U.S. citizen or green card spouse can file what's called an I-130 petition, which is also known as a petition for alien relative with USCIS. This petition requires evidence of the relationship and marriage. We typically include photos of the couple, emails, text messages, and affidavits from friends and family who know the couple. The petition's then mailed to USCIS, and it can take 6 to 12 months for processing. So what happens while you're waiting for the I-130 to be approved? Well, that, my friends, is a long answer, so pay close attention. One of the options while you're waiting for the I-130 to approve is called adjustment of status. If you enter the U.S. as a visitor, you decide to get married, and you wait your 90 days before you file your I-130, did you know you can simultaneously apply for the next step, which is called adjustment of status? This step is asking the government to adjust your status from a visitor or student or TN non-immigrant to that of a green card holder. The adjustment of status application is very lengthy, complex, and biographical in nature. Requires evidence of citizenship, passport photos, and a medical exam. This medical exam must be performed by a physician designated by USCIS. We can provide you with a list of designated physicians in your area. The adjustment of status application also includes applications for work authorization and travel permission. Did you know once the adjustment is filed, you cannot leave the country until your travel permit or advance parole is issued? Likewise, you cannot work in the U.S. until you've received the interim authorization to do so. Please note that it takes USCIS many months to process these applications. So the good news of this option is that you can remain in the U.S. with your beloved spouse. The bad news is you can't work or leave the country for almost any reason for several months. Once you've attended an in-person interview with your spouse and the adjustment of status application is approved, and if you've been married less than 2 years, you'll receive a conditional green card. The card will be valid for 2 years, but if you're married for more than 2 years at the time of filing, the green card will be valid for 10 years. So what happens if you can't remain in the U.S. without work authorization or travel permission for several months? Well, luckily there's another option called visa processing. This process asks the U.S. Consulate abroad to issue an immigrant visa, which will allow you to cross the border and enter as a green card holder. Please note, visa processing is handled outside of the U.S., and requires a series of forms and evidence to be filed with the National Visa Center, which acts as an intake center for the consulates worldwide. Once the Visa Center processes your documents, you'll be scheduled for an interview at the appropriate consulate in the home country of your citizenship. Like the adjustment process, you'll have to undergo a medical exam performed by a designated physician. The pros of the visa processing process are that you're not stuck in the U.S. for several months and you can continue your employment in your home country. The cons are that you're required to live apart from your beloved spouse for several months. Overall processing times for the immigrant visa option vary based on your country of citizenship, can be as fast as a few months or as long as a year. But can you travel while the immigrant visa process is pending to the U.S.? The good news is yes. The bad news is it has to be in a very limited capacity. You can occasionally enter the U.S., but you must demonstrate your permanent ties to your home country, such as proof of residence, employment, and tax returns, and that you intend to return abroad after a limited stay in the U.S. Upon approval at the interview, an immigrant visa will be placed in your passport. You'll use this to enter the U.S., and your green card will follow by mail. Please note, regardless of which process you choose, all U.S. citizen sponsors must demonstrate that they clearly earn sufficient income to support the foreign spouse in the U.S. If the U.S. citizen's spouse income is lower than that of the government's, the income of a second or joint sponsor, or the assets of the couple may be documented in the petition. In all cases, we must demonstrate that each sponsor has fully paid his or her taxes to the present date. As you've learned today, obtaining a green card through marriage isn't simple or easy. Neither option is perfect, and many of our clients choose adjustment or visa processing based on their life circumstances. But don't make this decision alone. Your consultation today will allow you to ask our skilled lawyers the relevant questions that will lead you to the right decision. Thanks for watching, and be sure to have your questions ready for your consultation. Have a great day. I'm Rosanna Berardi from Berardi Immigration Law.